Good morning, everybody. We'll just wait one more minute to just see if other people are coming in before we jump into our substance, but we will start with some welcome and hello and some starting comments. So first of all, good morning and welcome to the SpringLaw monthly webinar. However, today is a special event because I have my two esteemed colleagues joining us to help really build out some information around the new electronic monitoring policy that just went into effect a little over a week ago. So welcome, Constantine and Lauren. Really happy that you guys could join us. The three of us have been working together on building out a SWAT team package to really provide a one-stop shop type of package to help people with this electronic monitoring bill. But today's session really is about talking through all of the describing the background of the bill, the implications, and then a bit of Lauren will give us a lot of some practical tips on how to roll out the new requirements for workplaces. So let me turn it over to each of Constantine and Lauren to introduce themselves. Lauren, why don't you start?
Sure, thanks, Lisa. My name's Lauren, and I'm president of the Privacy Pro, which is a consulting firm based in Toronto. And we help companies comply with law, but also think about what data means to their business. And we are not lawyers, but we work with two very amazing lawyers when we're supporting our clients. But we take a very operational approach, and we're known for being practical.
Constantine.
Hello, everyone. My name is Constantine. I'm with nNovation. We're a boutique privacy and data protection firm. We do a lot of work with firms from outside of Canada who don't have a presence here, and also work with Canadian companies in order to and government organizations to address their privacy obligations.
Thanks again to both of you. I feel very privileged to have such wisdom on the session with us today. So before we really dig in, of course, we want to do a land acknowledgement, and we acknowledge that we are on the traditional territories of many nations and of peoples that were here first, and this territory is now home to many diverse First Nations, Inuit and Métis, and we are grateful for the ongoing welcome to the land. We are 2/3 lawyers on this panel, so we have to give a bit of a disclaimer. This is all legal information, not legal advice. And if you would like to fall asleep and read way more details, go ahead and read this slide about all the reasons why this is legal information. And let's jump in. We have a lot to cover today. Our SpringLaw monthly webinars are normally half an hour. Today is going to be an hour. We're going to try and get through most of the content in the first 50 minutes and then leave time for questions. So you'll see, for those who are new to our webinars, the software platform has a chat button. Go ahead and throw in questions. Our amazing Jess behind the scenes is going to capture all that and keep the conversation going. So please ask any questions along the way to keep this as conversational as possible. We're going to first talk about the background, then the implications, your game plan, and then questions. So we're going to start first. I'm going to move it over to Constantine in a moment, but we are first going to have a couple of a poll with a couple of questions. I think that I have lost the panel. I think I'm having some technical difficulties. I'm not sure if I'm still on, but I think I may not be.
You're still on, Lisa. I can still hear you.
I am still on. Okay, yeah. Okay, great. And you can hear and see me then?
I think that the poll overrides the video. I'm not sure.
Okay, perfect. Okay, so everyone can see the poll. Okay, good. This is good. Okay, so, there you are again. Thank you.
There we go.
We are a really tech-savvy firm that can't manage to do a poll without some with me having the glance. Okay, so Lauren, has a poll finished up then? This is clicking back and forth for me.
I see the results now. I see that we have 50% small, 22% mid-size, and 28% large, over 500 people.
Okay, well, that's great. Okay, that's helpful. Okay, and there was 2 questions. So what about the second question?
That one's up now. That one's
Okay.
asking where the company's located.
Okay, so while we're doing that, while people are doing the poll, and this helps us get, gives us the background and context for the rest of the session. So I'm going to move it over to Constantine to dig in and explain just the background and explain to us what Bill 88 is. Over to you, Constantine.
And unfortunately, presentation is also hidden from me, so I'm just going to go from memory. So just a bit of background. The interesting thing about Bill 88 was it was amending the Employment Standards Act. So it's not actually, quote unquote, a privacy law as we do see in some of the other provinces. But it is introduced privacy obligations to the Employment Standards Act. And what it does, in fact, is it applies to organizations employing more than 25 employees, and there are nuances there. But by last week, you were supposed to have a written policy that outlines your workplace monitoring, and you have to keep it up to date when it changes. It doesn't tell you you have to do anything differently. You just have to tell people what you're doing. Let's go to the next slide.
Okay, and you can see the slide now, Constantine?
I can, yeah.
Okay, good.
So it requires it has to be provided in writing, either on your intranet or posted. And this, of course, is important for organizations, as I've had to, in dealing with this. Not everybody is on the corporate intranet or gets email. So how do you let them know? Posting it in a conspicuous spot where you would post other, similar kinds of information. And you have to actually, this has also come up in, in the work in this area. There's always this sort of standard language in people's employee privacy notices that says, we use this for monitoring, very high level general kind of statements. This requires actually that it be much more precise. You have to ensure that employees understand whether it applies to, generally or to specific situations, kinds of monitoring. You have to tell them if their devices are being monitored. And you actually have to tell them the purposes for which the monitoring is being undertaken. So it's a more granular kind of document than organizations have been typically used to posting in the past, which have been, we may post it for, monitoring our network security and other, purposes. Next slide, please. So it has to, it applies to any organizations that have 25 more employees as of January 1, 2022. For future years, employers having 25 or more employees in January of any year have to have a policy in place by March of each year. So this year, of course, because it's past March, that had to be done by October 11th. Employees include probationary employees, trainees, part-time staff, employees who are on layoff or leave, officers of the corporation. And you have to include all Ontario locations. So if you have 25 people but scattered over, say, 6 locations, then you obviously are caught by the regulation. You have to include temporary staff. Part-time or casual people count as a whole person. You're not, when you have what's characterized as assignment employees or, from, agencies, temporary staff, you don't count them in your 25, but if you're providing notice because you are caught by you have at least 25 employees otherwise, your notice has to include those roles. And temporary staffing agencies also have to provide a notice for the monitoring that they're doing if they exceed 25 employees. So there's going to be some overlap that's going to take place.
That's a good point.
So what does the policy have to say? Well, as I said earlier, it's got to be a bit more granular. What are the circumstances of the monitoring, the purposes for which the data is being used? You have to include all forms of electronic monitoring. And as Lauren will get into this, understanding that perhaps is going to be one of the main challenges in implementing this policy. If no monitoring is being done, you still need a policy that says you're not doing any monitoring. Okay. And you have to provide the date that the policy was prepared and the date that any changes were actually made. So there is an obligation to keep this current in each year, as long as you're caught by that 25 or more employee threshold.
Okay.
Okay, so over to you.
Okay, so now it's all super clear exactly what is required by this new and somewhat vague piece of legislation. I want to talk about the application of it as a, oh, here's another poll coming in, first of all.
Yep.
I'm learning that it does bump. So can you see my slides right now, you guys?
No.
Yeah,
It's
okay,
completely
so it's like one or the other. Okay.
Yeah. Yeah.
But you get to see my cool Star Trek spaceship background, or you're only seeing the
I'm only seeing the poll.
Okay,
Yeah.
good to know. Okay.
Take over.
Can you read out the question and tell me the results?
The overall, how's the electronic monitoring policy been received by your employees? Positively, negatively, neutral, not sure. And so we have the majority is saying not sure, 60%. Neutral is 24, and then negatively is 9, and positively is 7. So
Okay.
I'm going to interpret that not sure, meaning maybe there isn't a notice in place right now, so you're not sure actually how they would respond. But let's go on from there.
Or this unsure, and then also how anonymous is this? You know,
Yes.
in terms of everyone else's, not the people on this session, but the feedback from employees. You know, people tend not to always be
You
forthright.
lost your slides, Lisa.
Okay.
Thank
you. We will get this by the third round of questions for sure. Okay, so a mix for sure. So I'm going to talk about the employment law implications. So Constantine is our privacy law expert on the panel. I do employment law. So in the workplace, what is the implication of this piece of legislation? So first of all, it's important to note that the application and the requirement around disclosing the electronic monitoring is not just with respect to devices that you provide to your employees. It's anything you do in the workplace. It's all monitoring that you may do, whether they're working remotely, in person, hybrid. That's just added this extra layer of complexity to it all post-pandemic. And it includes all kinds of monitoring. Some that is a little bit old school, you know, the GPS or geolocations, cameras, performance monitoring, so, you know, keyboard stroke type things, call center, you know, there's a whole range here of what is going to be monitored. For a big chunk of workplaces, really it's if email and chat and general use of the electronic systems are being tracked, you know, this is what needs to be disclosed. So what are the consequences? The bill does not limit the kinds of monitoring that is to be disclosed or not disclosed, and it doesn't restrict what the uses of the monitoring are. So it doesn't say you have to disclose if you're monitoring because you want to discipline someone. It says you have to disclose all monitoring, period. So what are the consequences if an employee is concerned or has a complaint about the monitoring in general? The reality is, and this is maybe some of the good news for employers right now, the ESA, and so first of all, this is Ontario legislation from anyone outside of Ontario. The ESA specifically says you have to have a policy in place, and it gives the parameters around the policy that Constantine already talked about. So you have to have a policy. It needs to disclose what the monitoring is, but it doesn't say exactly what all of the criteria and details of that policy needs to be, and it doesn't really say anything else. You just have to have a policy. It doesn't even have to be a good policy. It has to be a policy that meets the legislation. I mean, it should be a good policy, and if you get it from one of us, it'll be an awesome policy, but it doesn't need to be, there's no, it's just having a policy. The act of having a policy is really what the legislation's about. So are there any implications outside of the ESA? You know, we have yet to see. There's certainly the ecosystem of privacy law and expectations. If you're outside of Ontario, which this ESA provision doesn't apply, but you know, there across the country, there's all kinds of different privacy implications. But in Ontario, it's hard to say that there will be any implication outside of the ESA at this point, other than the usual implications otherwise, right, of acting in good or bad faith against your employees. The major impact from the employment law front is, can you use the information that you're gathering? And so this is all about evidence, right? So these are laws of evidence. If you are monitoring employees and you happen to, find some bad apples through some of the electronic data that you're gathering, can you use that data to discipline an employee? And so this will it will depend, I'm afraid. It'll depend on a couple of things, and I'll go through some likely to be usable and not likely to be usable scenarios in a moment. But in general, this is the main legal test. Is the purpose of collecting the data, is it consistent with what you're going to use it for? So is it for discipline? If you're unionized, what does your CBA say? This will be a really important piece of this, and that's gonna, no CBA can contract out of the Employment Standards Act, but there are often nuances that are more in the CBA, and we have a long history throughout Canada of unionized workplaces really arbitrating privacy issues. So if in doubt, the CBA will probably capture at least all of this already. And then in terms of disciplining employees, what formal notice requirements do you have in place already? So, do you have do they know that you're monitoring all of these things? And if you're not disclosing this to them already, and often you'll see, like, the cameras in the workplace, you'll see a sign, cameras are being used. That's exactly for this purpose, to give everybody notice that this is happening. So then, there's the esoteric question, should you rely on the data being gathered? It can be helpful in some situations if you really do truly have a bad apple in your workplace, but you still won't be able to rely on it if it's been super sneaky behind the scenes and you haven't disclosed it, especially now with the ESA is requiring a policy around that, but now you're breaching your own policy if you don't adhere to your own policy. Okay, so here's the actual legal test. Before it was more just my intro slide about this. Was the measure used necessary? So when you're deciding whether or not, when an adjudicator is deciding whether evidence can be admitted to support a wrongful dismissal, for example. Let's say you want to fire someone because they've done all kinds of bad things online on your systems, or breached a bunch of stuff on your systems, and you've noticed it through the data that you've collected in your day-to-day stuff. The rules will look at a few things. The measure, that the way in which you gathered the information, was it necessary? Was that measure likely to be effective? So if you're, some of the older case law talks about cameras, is it actually effective? If the cameras aren't even on a work area that you're concerned about, etc. And then, was the loss of the employee's privacy proportional to the benefit gained? So it's always going to be this cost-benefit analysis. And then really the guiding best practice is there a less intrusive way to gather the information? It really will almost always come down to that and consent. So is there a less intrusive way to gather the information? You don't need to do a deep dive spying on all of your employees to gather some reasonable management type pieces of information to manage your workplace. Okay, so here's the likely to be that you can rely on, and then less likely that you can rely on scenarios. So if you're gathering data through your day-to-day business operations to improve customer service, so we all hear that when we call any customer service line, that our calls may be recorded for performance, or not for performance, for quality assurance and training purposes, right? So if it's to improve customer service, if it's to protect company assets and your network security, right? If there's like a tangible, practical business reason, then you're more likely to be able to rely on evidence that you've gathered because of that, if that was the purpose for which you gathered that information. if it's to enhance employee safety, if it's, for example, GPS in vehicles, if it's for, tracking stolen vehicles, if there's investigations to determine a potential breach of law or contract, that's probably your biggest hook as an employer. If you haven't quite sorted out exactly the purpose for which the information has been gathered, you will be far less likely to be able to rely on evidence gathered through electronic monitoring if your performance managing employees where those privacy interests really outweigh the business needs. So you can't start spying on all kinds of personal stuff for a pretty benign workplace attendance issue, for example. There has to be a balance. If you did not provide any advance notice and no consent was given, right? So I think the main point of this bill is to just get some transparency around all of this. Is there less intrusive option available? And then again, in unionized workplaces, keep an eye on your CBA. Your HR law risks really are across the board in a couple of different buckets. So in all provinces, you can worry about constructive dismissal if the act of monitoring and the behavior involved on the management side is so egregious that it basically renders the contract null and void. I think this constructive dismissal claim will be a more remote concern, but invasion of privacy torts in all provinces now, grievances in unionized workplaces for sure, and then claims under privacy acts in other provinces. We do not have that in Ontario. As you know, the PIPEDA, it does govern, but it expressly excludes employee stuff. So Ontario has this weird patchwork and gap. This piece of legislation really closes a part of that gap. But really the biggest risk around overextending your use of electronically monitored information is attrition and business reputation. The internet will not be your friend on this. We live right now in a moment of employee empowerment and employee big voices that will tell everybody about how rotten you were about all of this. So I think it's imperative to disclose and comply with this law more than anything for that business reputation issue. Okay, finally, key takeaways is, as Constantine already said, these generic high-level kind of statements about, we do or do not monitor will not be enough. You actually need to specify some of the details and from the employment law perspective so that you can rely on these things. Otherwise, it's too generic, and if the policy isn't even enforceable, then it's a problem. The exercise of creating this policy has been a real education piece for all organizations to really get a sense of what your own software is actually gathering and what's already happening. And Lauren will go into some good detail around that. Really just have a discussion with your staff and figure out, do you really need to monitor all this stuff from a performance management and HR perspective? Okay, your game plan here. Okay, I'm all prepped for the poll question and pushing all the right buttons when we do this. So we have one last poll question, and can you read it out to me, Lauren?
Did you find it challenging to draft your electronic monitoring policy? Select one. OMG, yes. Nah, we good. Or what electronic monitoring?
Yeah, there we go. Yeah. We're only a week after, so zero judgment on this. It's only a week after. The Ministry of Labor is busy with lots of stuff. No one's gonna come knocking on your door today. It will be good to get it done. Okay, we did it. Oh, we didn't do it.
Was it challenging? No, we good. Almost half people. OMG, yes. We would love, so if you submit questions, I believe only we see them. I would love to hear about the challenges that you found. And 21%, what electronic monitoring policy? Well, now you will be able to write one because Constantine and Lisa gave you everything you need.
There, yeah, exactly. Here we go.
Okay, I'm going to talk about the game plan. So Lisa just mentioned that these generic statements are not going to work. So for those of you that were in global companies, well, October 11th isn't 20 days away, but it was last week.
Oh,
For those of you that are in global companies and maybe that are working in the US as well, you might have already done this you think you've already done this through New York or Connecticut laws that make you say, you know, the little screen when you log in, this is your activities may being monitored. That's not going to work. So you need to figure out what exactly you're doing, decide what to do about it, because you do have options, publish the policy, and then just be thoughtful and communicate with the employees. So next slide. Okay, these are a lot of types of monitoring that takes place. These slides are going to be available, and these are, for the most part, complete sentences. So I'm not going to go through them all. I'm actually going to give you some examples. And some real examples of real types of software. And I want to get ahead of the question we experienced last time is people saying, here's a very specific thing. Is that monitoring? Well, I'm the only non-lawyer on the call, but I can tell you what my colleagues would say, which is, of course, it depends. And so it depends on what you're doing. Is everything monitoring? Think it all the way through. Play it through. Is this something that, put yourself in their shoes, is this something that I would want to know about? Talk to your colleagues that are using them. And so let me just go ahead and go into some examples. If you could go to the next slide. All right, this beautiful collage is just a list of some of the most common or most popular or highest rated different types of employee monitoring solutions. So if you're looking around and if you're a privacy person that has spent any time doing privacy impact assessments or third-party risk assessments, some of these logos will look familiar. If you're an HR person who is responsible for doing monitoring or a consumer of the reports, these may look familiar. I want to categorize these into 3 buckets, okay? There's a bucket of monitoring that is to be expected, and that's the things that Lisa and Constantine were talking about around putting GPS in your trucks, putting a security camera in a storefront pointed at the cash register, doing monitoring around data security or financial checking for insider trading. You could go to the next slide. I have an example of this one. This is a screenshot from the software called GeoTab, and it is used, you can see, to look at the driver safety, the fleet mileage, it's logistical. There is a question on the monitoring of company vehicles when they're being used. When it says, would you care to opine on GPS in company vehicles when employees are allowed to take them home or use them for limited personal purposes? I will opine on that, and my opinion is it depends. It depends on what you're monitoring. Nice. And the point is, you've got to be transparent, and if there's and it has to balance. What are their privacy rights with what are you doing, and how can you do it, and what do you need for your business, and how can you do it in the least intrusive possible way? The next slide has another really common monitoring that type of, oh, sorry, can you go forward to the one that says data leakage monitoring? My slides are in a different order. One more. Sorry about that. All right, so data leakage monitoring. This one's for data security. And so this is one that also fits in that first bucket of things that people don't seem to be surprised about. There's a very legitimate business purpose for making sure that data as a corporate asset is not going outside the company, that you're not sending out all the credit card numbers of your customers and that sort of thing. And that's when you see those little notices about your activities may be monitored, probably back then, that is what people were thinking of. So that's that first bucket. If you could go to the gong slide, Lisa, I put that one in the second bucket, where employee monitoring is sort of a side effect of a business process, like sales enablement. And so we talked about every time you get on a call and it says, this call may be recorded for quality and training purposes. You do have obligations to get consent and inform the customers that are on the call, but there's multiple parties on the call. Your employees are on that call as well. And some of these software tools go far beyond just recording the call. Look at this one on the bottom right. It says Jackie can increase stage conversion by talking more about value, not competition. That's AI-based insights about this person. And so go back to the conversation that Lisa was talking about, what you can do with this data. What are the legal consequences of using AI-based systems that are judging people's performance? And do the employees know what you're doing with this? Do they understand that you're not just recording the calls so that you don't have to take notes, but you're giving them a rating of 7.8 out of I don't know how many on the coaching scale? They need to understand that you are monitoring their behavior for that purpose. So that's first bucket, is those really straightforward ones that none of us would really be surprised that they're happening. Okay, second bucket, monitoring is a side effect. Third bucket, okay, brace yourselves for this, because third bucket is what to me as a privacy person is problematic. And so if you could go to the TerraMind slide with the orange on the top. This third bucket is the really intrusive type of monitoring that we saw get more popular in the pandemic when people were shifting to work from home. Employers felt like they were losing control over people's time, and a whole bunch of these software tools popped up, and a lot of them have free trials. They're very inexpensive. You can purchase them with a credit card. There's a lot of risk there that we refer to as shadow IT, things that aren't necessarily coming through procurement. And what you can see on the screen here is a tool where the person doing the monitoring can go and look through your screen without you knowing about it at any time. And if they miss it in real time, it is doing these 40 to 50 second snapshot recordings, again, using AI. I put scare quotes on AI because I think that word is used quite creatively sometimes. I don't know this product. I did walk through a whole demo of it, but the AI is judging their time as productive or unproductive. You can click through these on the demo and you can see that he's on Facebook, he's doing emails in Gmail, he's not working, he's unproductive, he's watching YouTube videos, but you can watch what he was watching. And this software is bragging about the fact that you can deploy this in minutes without actually letting anybody know about it. So that's that third bucket that I think, to me, as an Ontarian, I'm so happy that in the absence of privacy law that requires transparency on this, we are getting privacy rights in a way, because we're getting the right to know. And that's one of the first principles of privacy law. If we get one, when we get one, maybe, that'll be included in it. That's what people in BC and Alberta have. That's what federally regulated employees have. And so we're on our way there. And so I showed you a slide with all of these logos on it. Some of them will be unfamiliar, although you might be using them. So how do you find out? That's the first step. Like, let's just assess the situation. You don't go straight to writing the policy. You go straight to figuring out exactly what you're doing. If you could go to 29, I believe, it's the what monitoring activities are in place. There we go. Number one, ask people. This is pretty straightforward. People are humans, not resources, not assets. I find that I have not seen a single instance where an employer does this in order to be intrusive, in order to hurt people, in order to judge people unfairly. That isn't why people are doing this. Sometimes it was a free trial. Look what we saw with like Clearview AI. All these police forces got it for free, and it wasn't really well thought out at the top. And so that happens in the business world too, is these vendors may have even just added features. like you bought the software because it does one thing, and then they just start adding in other tools that you didn't know about. Constantine, you looked like you wanted to jump in.
Well, a great example of this is Teams. If you have an Office subscription, you have the ability to elect a feature within Teams, which will actually report back on, is somebody moving their mouse around? And, are they paying attention during, a video call? And, whether this is actually a good or valid measure of productivity or engagement is a open question. But often these features have been added, especially, as Lauren, as you pointed out, the last 2 years, because people have been concerned. How do I measure productivity when I now have a distributed workforce, when people are working from home? And I think it does lend itself to really some, important questions. How do we measure productivity? But these are being put into as features, programs that you didn't think maybe would be used in this fashion. So you have to be conscious of, featureitis, the tendency to just simply, oh, that's cool, we just keep adding. One of my favorite quotes for my clients is, never attribute to malice what can equally be attributed to ignorance. It is often the case that people just stumble into these kinds of decisions without really thinking, as Lauren was saying, through the consequences.
100%. When you go to ask people, expect and respect reluctance to share details. When you go to the IT security department and you say, I need to understand exactly what kind of monitoring you're doing, they might go, well, we can't tell you that. You could go all the way up to the CISO, and she's going to say, if I told you that, you would be able to get around it, because you probably, if you're on this call and you're responsible for this, you're also an employee. And so that's okay, because remember back what was required in the policy. It's not that you understand every single aspect of what's being monitored. It's that you're telling them what you're doing, why, and helping them understand what's going on. You should expect reluctance, and there's reasons for it in some cases. Maybe somebody downloaded something they weren't supposed to do. It's perfectly reasonable for them to be reluctant to share that information with you. And so we have a couple of tools that you can use to help them double check, maybe help someone help you double check. My team put together a list of these common software tools, the logos that you saw on the previous screen, so you can kind of check against the systems that are installed, and maybe starting with procurement. Where's the money going? If money is leaving your company for software, it's a good place to start looking at what kind of software you're using, right? This is electronic monitoring. And so we should have some kind of a connection to the type of software that you're buying.
Lauren, I've been giving that, I took that advice from you, and I've been telling clients that too. Just go look at your SaaS subscriptions and start there, and that will probably be a massive part of it. Because the issue that I'm hearing from clients is that they don't know where to start. It just seems very daunting and overwhelming, and how detailed, how not detailed. So yeah, starting with just what do you pay for right now? Go look at your latest firm credit card bill if you're a smaller organization, or some sort of procurement list somewhere that will give you that list to start.
Assume good intent from people. Assume they had a reason for installing the software, because they probably did. Once you've got that list of all the different types of software that are being used, ask yourself, does this spark joy? It's kind of joking, but also it's true. Again, you ask somebody, why are we doing this? Are we doing the right thing? I have seen, honestly, 9 out of 10 times, people go, now that I think about it, maybe we shouldn't be doing this. And so that's, in my opinion, as a privacy person, a great outcome. So you ask yourself, what's the goal? Constantine started to speak about this. What are you trying to measure? You should ask yourself that. And does this actually measure that? Does mouse movement measure productivity? Mine's not moving right now, but I'm feeling really productive. We're having a good conversation. What are some of the harms that could be done? Think about how that would disproportionately impact somebody who maybe had kids at home that they had to tend to. Maybe somebody who is pregnant and is having to use the restroom more and step away from their desk more. There's some real consequences to this beyond just it being pretty intrusive. People should be thinking through the harms to these people. Is it the least privacy intrusive way to accomplish the goal? So looking at somebody's personal use of Facebook while on the job, I understand you don't want to pay people to use Facebook. Is looking at their Facebook view the least intrusive way to accomplish that goal? No, it's not. Block Facebook. Don't let people access that from your servers, right? Look at their outputs. Are they accomplishing their job? There are reasonable expectations now, especially for knowledge workers, to be kind of multitasking and balancing, and our lives have merged, right? Since we've started working from home, things have changed. And so, think these things through. Is it working? Are you like catching people doing things? Is it having, what are you learning from this? What kind of different business decisions are you making from it? And so how do you know if it's actually working? And if what we think of as, is it working, as is it going to show evidence that somebody did something bad, go back to Lisa's conversation about whether you can actually use this information, because she said sometimes you can't. Okay.
And I'll jump in and say, these questions that Lauren is posing, this is actually what we call, part of doing a privacy impact assessment. And those are the magic words that we all love in privacy, because it's about consciously adverting to risk and consciously accepting risk, as opposed to stumbling into it, which is what many organizations do. So this is really about also maturing to some extent the processes within your organization to say, when we introduce something like this, have we thought through the consequences?
Great.
So we talked about the legal and regulatory consequences, but what about the natural consequences? How will people feel about it? How would you feel about it? How would you feel knowing that everything you've done today was being watched without your knowledge by somebody within who knows what department, the security department, the HR department? It'd probably feel pretty gross. So adjust your behavior accordingly. I don't know how to, it's not complicated, right? That's one thing. Okay, how will your employees in other provinces feel about it? There is a question around the number of people in the provinces, and I'll ask one of my colleagues to answer it in the chat. I think it's pretty specific, but it does bring up a good point, which is that a lot of companies, and we saw this in the poll, are operating across multiple provinces. So here in Ontario, we started with this, Lisa explained, the regulation does not say that you can't do the monitoring or that there's certain rules around what you're doing. You just have to tell people. That's true in Ontario. That is not true in BC, Alberta, and Quebec. Those provinces have privacy laws. And most of you are not doing different things for employee in Ontario and in BC. If you're in Canada, across provinces, you probably have centralized systems. And so Ontario is going to publish this policy. And then in BC, where people have redress, they have the ability to go to their privacy regulator and complain, you might have some effects in that sense. And so think it beyond this legal and regulatory consequences here. And how will it look on TikTok? We are dealing with a workforce that is incredibly savvy, incredibly intolerant of abuses by their employers. We're dealing with all these buzzwords like the Great Resignation and the quiet quitting, and just think about the reputation of the company and how much that matters, especially to young people, right? Some of us, when we started out, we were not so concerned about that, but this new generation is extremely concerned about that. They're not going to work for a company that they feel is unethical, and so that was one of the consequences we talked about before with regard to attrition. So you kind of have to look holistically. All right. So now you figured out what you're doing. You have some choices here. I'm not here to tell you what to do. I don't know how to do IT security, data loss prevention. I don't know how to do fleet management. And so you know what your business needs, and you have options. So one, stop doing it, or adjust the approach a little bit, maybe adjust the settings so you're not surreptitiously monitoring people, and you brag about it. If you're doing something that's maybe privacy intrusive, put it in the policy, and just those are some of the options. You can keep doing it and be transparent. That's our favorite option, is being transparent and complying with Bill 88. You always have the option to keep doing it, don't tell anyone, and hope that no one finds out, right? That's a realistic decision that businesses make, and what we want to do is help you understand what the risks are, and so you can accept those risks. And so, yeah, you've got choices. And let's skip that one in the interest of leaving some time for questions, and talk about communicating thoughtfully. So yeah, just treat people like people. You have to post this on the intranet and or on a message board somewhere if people are not online. I do not recommend just doing that with no kind of communication at all. I would say, hey, this is a new policy. If you have any questions, these are how we protect your privacy rights. This is how you can, get access to the data, and consider alternatives, and say, if you don't like this, we have to monitor your phones, because you've got sensitive corporate data on those phones. And so we need to be able to remotely wipe them. We need to install our data loss prevention software on them. And we have a bring your own device policy. So if you're going to bring your own device and have like the nicest iPhone, then you have to install this software. If you are opposed to that, here is a phone that we own that you don't have to do anything personal on. That might be a way to give people choices. But listening and also communicating openly, it goes a really long way. And I don't mean to seem like touchy-feely or preachy about it, but that is how we recommend avoiding complaints to the privacy regulators, is to just talk to people. They'll say that same thing. They will say, did you guys talk before this complaint got submitted? So I think it's good practice.
Well, and just from the employment law perspective as well, if you're going to roll out a policy, which you do need to under this legislation, you have to tell people about it. You have to, in this case, it's not even notice at this point because it was required to be in by October 11, but you have to tell people about it. Especially if you at some point want to rely on any policy in the workplace, if people don't know about it, then it's really hard to lean on that as any sort of progressive discipline type of piece.
All right.
Here's some other questions. Sorry, go ahead.
This is our last slide. And so we'll just say we can help. We're helping, we've helped companies with this before. We'd happy to help you. We put together a service package. We will be sending out more information about it. We wanted to make it really easy because we are past the deadline. And so we just have this fixed fee service package put together where you get to talk with all of us, each of us. You have a template that we will help you to customize. And I mentioned that my team has put together that list of software tools and an interview questionnaire that will help you get to that information about what they found. And then on some of these specific questions, like, is this monitoring? What's the number of employees here? We can provide you recommendations around that, and then my colleagues can provide you with that specific legal advice. And so thank you for listening. And now we would like to listen to whatever questions are still outstanding. And please feel free to put more questions into the chat, and they'll get through to us.
So one question is, if the organization has 10 staff in Ontario and 90 in Alberta, does that qualify as over 25? No, it's got to be on Ontario employees that have to hit that threshold. There's another question I will answer because I've spent some time working on this with clients about GPS, where company vehicles are allowed to be taken home or used for limited personal purposes. This is a really good question because it's very common. And so really what you've got to think about is not collecting more than you need. If they're off the clock, really you should have the capacity to actually just turn off the monitoring. You don't want to know what they're doing in their off hours. You do want to make sure they understand that during their work hours that monitoring is taking place, and why. Workplace safety, productivity, what have you, whatever the rationale is that you're collecting that GPS information is legitimate, for as long as you've communicated it. But you really want to avoid over collection of data, and especially again in the context of where you're allowing personal use, whether it's of devices or of vehicles, to essentially limit it so that you're again not observing or looking into somebody's personal life. There was the question about third bucket feeling icky, and I've lost track back on the slides which the third bucket was.
I can take that one. I put things in buckets or groups or categories. I don't know why. Yes. Bucket. It's weird. But that third bucket was that really intrusive monitoring. So it feels icky, but what makes it so bad from a privacy perspective is that if people don't know about it. People need to be able to, privacy is about agency. It is not about secrecy. It's not about the fact that, it's not about what they're doing. That's the part that feels icky. But privacy isn't just about like keeping things confidential or keeping things secret. It's about giving people choices. And if they don't have a choice about being monitored in that way because they don't know about it, then that's not fair. That it's fairness, right? Another issue is that they're going to need to, they should have access to their data. They should have a right to correct their data. We don't under regulation. But they are the principles of privacy that we do consider a human right here in Canada. And so it's about being able to make informed choices and companies finding that balance of, is the intrusion on privacy, is it worth it? And I would say that meaningful choices, the federal regulators have outlined what does it mean to have a meaningful choice. And when your choices are quit your job or have bad things happen to you, that's not a meaningful choice. And so take it or leave it. We monitor everything you do and we watch what you post on Facebook and we read your DMs. Just quit if you don't like it. That's not a meaningful choice. It's not respectful, and it doesn't follow the spirit of the way that Canada, and by extension, of course, Ontario, thinks about privacy as a human right. So I'm now speaking to outside of that regulation and that kind of the difference between can you and should you do this kind of monitoring.
And the other thing too, there is implication, obviously, in BC and Alberta and Quebec, they can ask the question, what do you know about me? And of course, revealing the monitoring that's happening in an organization will yield those kinds of questions. So you have to be able to respond outside of Ontario to access and correction requests. And I'm just going to expand on, the creepiness test, which we often talk also about in privacy, which is, could you explain this to, an older relative? Would you feel comfortable explaining this to your mom or your aunt in the context of saying, you know, here's what's happening? And that is an important sort of test or element to, even if you have, I think, communicated, if it leaves people feeling, you know, and Lauren alluded to this before with the, you know, the great resignation and quiet quitting, you can have a very negative impact on morale if it's seen as over the top. Also, and this goes to Lauren's other point about ethics versus law, you know, when people push the boundaries, and I mean, for instance, you know, always on cameras on laptops so that you always are able to, and this is actually being done in the US, you know, it almost gets to the point of where, well, I'll give you an even more concrete example. When companies started this notion of asking for passwords to, you know, people's social media accounts, some US states immediately passed laws prohibiting it. You don't want to become the reason a legislator passes a law. Not a good look, right?
Yeah.
So bear in mind that when you push the boundaries of ethics, there's often a legal response. Just to think
Well, can I be the counterbalance here to both of you,
Sure.
to both of you two hippies around privacy, because there's also management rights and employer, you know, businesses needing to run a business, right? So just to round out the perspectives here, businesses do have a legal right to run their business. The employees don't have a legal right to privacy all the time for everything. If it's on a company device, if it's in the workplace, and in the workplace has been expanded post-COVID, especially with remote working. And so I think employers should continue to feel some comfort around managing their workforce, right? And if we were all in person still, you would see the person at their desk, you would see whether or not, especially for knowledge workers, but you would see the workers sitting there whether they're working. And to be fair to many, especially small employers who don't have the bandwidth to do this in a more nuanced or, you know, progressive discipline sort of way, they need to know if their employees are working. And more often than not, this only comes up when there is a problem. An otherwise very productive employee, no one cares what they're doing if they're just having great output. So, you know, and there is a lot of attendance issues right now, lots of people on stress leave, lots of labor shortages, managers who are stressed because they've had to navigate a constantly changing environment for the last 3 years. They're going on stress leaves or just not equipped in the first place to deal with this. We are in a moment right now where many workplaces are overwhelmed. And so I love this legislation. I think it is a good thing, and just disclosure and transparency is always better than not, but it doesn't mean that employers can't manage their workforce. There was one, oh, sorry, go ahead, Constantine.
Absolutely agree, Lisa. This is not to say employers, you know, are entitled to protect their network infrastructure, to make sure people are acting appropriately according to, you know, the company's policies. Privacy is not about you can't do it, it's about let's find the right way to do it.
Yes.
And
yeah,
that I think is a critical sort of, you know, element. And I think there was another question.
HR versus IT, who does the policy? I'll take that one because it's both, right? HR tends to take a lead on you know, the circus master on all of the policies, but you're going to have to consult with IT. You're going to have to talk to them. It's two very different personalities probably at the table when you're doing that, and the reluctance you were talking about earlier, Lauren, I have observed with some of our clients. It's the IT folks who are annoyed that they have to do all this extra HR stuff, right? And like, just let them do their job. They're too busy with other stuff, but they do have to get granular, and then it's usually the HR who will bake that into something. If you're in a smaller organization, it's the owner operator that's going to do all of this, but smaller being 25 people, right? I mean, it's only if you have more than 25 employees, but many 25 employee workplaces still are owner operated and don't have a great big HR and IT department to deal with this. So this isn't an easy policy to create, to be really honest. And then there was one more, would the number of external independent directors of a company board, quote, ever be in some way considered to be part of the calculation of 25 employees or workforce members? I would think not, but curious. And asking for a friend, perhaps. Constantine, what do you think?
Officers are definitely included.
Yeah.
I think that it's an interesting question. What I think you have to look at the function of the director to determine, are they really acting in the role of an officer as well as perhaps a director. Independent board members, I would say board typically would not fall into the calculation. But again, you have to look at their role. Are they fulfilling responsibilities that might be characterized as like an employee?
Okay, I think that's all our questions that have come around. Any final comments from either of you two?
It's not too late to get started. You know, I was going to respond to Lauren's last point on her slide, which is, hope for the best. I have always taken the view that hope is not a strategy. So, it's better to get out ahead of these things and not, I think most organizations are, as Lauren said, try to be reasonable and aren't actually consciously doing anything that they would, be embarrassed to admit. I do think it's going to drive people to look at, well, maybe this is, now that we actually have to talk about this, maybe not such a good plan. Lauren and I, you've had that conversation with me. It's maybe making some people rethink some things when you have to own up to it, when you actually have to disclose it. And that's part of that earlier conversation of the creepiness test, right? It's like, well, now that you have to actually say something, maybe I don't want to do that anymore.
Well, we'll have to go back to the monitored talk. I thought I said assume the best. I meant to say assume the best of people. And I think it goes for employees as well. Because I agree with you, Lisa. People need to run their business. I'm a business owner. I don't happen to monitor my employees. But they're like, it's hard. It's really hard with people being sick, with, not knowing what people are doing. And that's where I think too, like anything could be considered monitoring, things couldn't be. I think it's just nuanced. And I think that this regulation is a piece of it that is going to prompt really good things for both sides. But there has to be a balance, absolutely.
Exactly. Yeah, and good conversations, right? It's awareness. And I would say, Constantine, it's not just asking, your elderly aunt or uncle. Ask your 14-year-old daughter, and they will have very clear views on what is private and not private. Very, and they will post everything online, but have very clear views about what is private online. So that's our workforce. Yeah,
definitely,
for sure.
Better. Yeah.
Yes.
Because they're savvy.
Yeah. Oh yeah, I know. I have a 14-year-old daughter. She thinks she's my boss, so for sure. Okay. I think we've got to end it at this. Thank you to both of you for joining us. Thank you to all of the attendees. We had a lot of people stay right to the end here. We will be circulating a link to the recording for you to show your IT people, for example, what they need to do to help you out. And then we'll distribute some information about the SWAT team service package that we have as well. Thanks to everyone and have a great rest of the day.
Thanks, guys.
Thank you.
Bye.